issues in place of provision of service rules. Through these rules, place of provisions of service rules 2012, which has come in 2012, but yet still there are many controversies which are there. Many people, we don't understand that how this rule will work out, because some of the rules has been drafted in that manner. So we have thought it fit that let us have a meeting, separate meeting by itself on this issue, and for that matter we have requested Mr. Naresh Thacker from ELP and Mr. Jitendra. He will lead the matter and Naresh will chair the session. Now I will request Narendra to formally introduce both of them. Narendra.
Good evening, one and all present here.
Good evening. Yeah.
I'm pretty sure that economic law practice is not a unknown name for the indirect tax practitioners, and likely when the partner of ELP, Naresh Bhai, who has appeared before Supreme Courts and High Courts in various cases, so even he is not unknown for the indirect tax practitioners here. Still, I'll take this opportunity to formally introduce both today's group leader as well as chairman, who both are from ELP. Today's group leader, Mr. Jitendra Motwani, is an associate partner with the Mumbai litigation team of ELP. He is graduated from KC Law College and has obtained his solicitor's qualification from the Bombay Incorporated Law Society. His area of specialization covers all form of indirect tax, that is excise, customs, including FTP. Apart from advising clients on various aspects of IDT, he also actively appears before various forums including Supreme Court, High Court, tribunals and all quasi-judicial authorities across India. He has authored several articles in varied publications and is regularly called upon by professional bodies to speak at conferences and seminars. Prior to ELP, he was with PDS Legal and DSK Legal. With this, I request all of you to carry out a huge round of applause. I request Ashit Bhai to present a memento on behalf of Chamber as a mark of love and affection from us. Today's chairman, Naresh Thacker, is a partner at ELP. He is a litigation and dispute resolution partner specializing in tax and commercial disputes. He is qualified lawyer with the additional attribute of being a solicitor in England and Wales. He has successfully represented client in matters pertaining to economic offences before diverse tribunals and courts in India. He is actively involved in the form of alternate mode of dispute resolutions and has managed a number of ad hoc arbitrations. He has been part of mediation and conciliatory proceedings at the client behest and has brought them to fruition. He is currently active in a number of professional organizations including the Law Society UK, London Court of International Arbitration and AIFTP. He is often quoted by prestigious international journals and his articles continue to appear in trade publications around the world. Prior to ELP, Naresh Bhai was practicing as an independent counsel on indirect tax and litigation matters. With this, I request all of you to carry out a huge round of welcome Naresh Bhai. I request Ashit Bhai to present a moment to Naresh Bhai. Sir, all yours.
Good evening, friends. I'm not new to the chamber. There have been earlier occasions when I have also conducted these study circles. Now today I have my junior colleague with me who will do the honors. And it's a good thing, because then I can be more laid back until such time as the questions start flowing in, because that's when maybe I will have to take it up. But even then I would rely more on Jitendra. I must say that he is an excellent professional, and I'm sure you all will give him an extremely hard time. I want you people to do that. That will be the true test of knowing how well he knows the place of provision rules. It's a very interesting topic which you have chosen, and while it is interesting, it has also been extremely perplexing for us to go through the rules, and frankly I must tell you that while going through the rules I did realize, and I was telling Ashik Bhai about it, that while I was going through the rules, once again I did realize that there are chances and there are situations wherein we can have a sort of a constitutional challenge to certain portion of the rules, and more so when we are looking at the application of these rules to certain situations where you otherwise have a case for export, and therefore there ought not to be any tax liability at all. But yet the reading of the rules, specifically I think Rule 7, it seems as if it's a scenario wherein Rule 7, the way it would otherwise apply in a given scenario, would also require a tax to be paid in respect of a transaction which otherwise would be a pure export transaction. At the same time, if you look at Rule 8, that again is a situation, that again is a possible scenario where you may have a situation that you have provided the service out of the country. In a sense, the effect of the service is felt outside the country, but yet the mere fact that you have the recipient as well as the person who is actually providing the service, both situated within the country, you yet have a case for paying the service tax. Now, if you look at the guidance note itself says that when you have an indirect tax, the very nature of the tax is such that it ought to be consumption-based tax, and I don't think there can be any dispute on that at all. All indirect taxes in that sense have with the moment you say indirect tax bearing, it becomes a consumption-based tax. If it is a consumption-based tax, the question really that one needs to answer is that, is it in every scenario that you are required to pay tax? I would not think so, because and especially where we are looking at a scenario of an export, I would not think that tax ought to be paid in case of export at all. What is the stated policy of the government? The stated policy of the government, and we can very safely say this, it is that the exports ought not to be taxed at all. So if there is any tax and it is on export, that tax either is to be rebated, or you get a refund, or you get an exemption, or you, in the first instance, you are not taxed at all. However, this seems to be a quantum shift in the policy of the government, in a manner and the fashion in which the provisions have been framed. Now, if you look at the provision, namely 66B, when it started off, what did it say? It's the charging section. What did it say? It only spoke of a tax on the activity of service. They changed it in 2012, and they changed it in 2012 with a stated purpose, namely that ultimately you have a separate rule for export, which is the export rule 2005. You have a separate rule for import, which is namely the import rule of 2006. We want to consolidate all those rules, and we want to bring it in one silo, and therefore we want in that sense one uniform rule which will deal with all the scenarios possible. And one of the most important purposes for bringing this rule in is our move towards GST. Whenever that happens, hopefully with the new government, what we are looking at, if it comes along, one of the situations which will arise is that whereas this service being provided, which state ought to tax, if at all there is a tax, what portion of the amount ought to be taxed, what ought not to be taxed, value, what would be the value. There will be various issues which would arise, and one of these issues would be place of provision, because each state will want its flesh. So who and which state is ultimately going to get its pound of flesh is the question. So with an aim and an objective to address and answer these gamut of issues, you have the place of provision rules. Great objective, and I think a right move also. I don't think there is anything wrong in the government making the move. What is questionable nonetheless is that when they brought about these changes, they also brought about a change in the main provision itself. So you have the section 66B undergoing a change. The change in section 66B, and I will only read out the portion, where the change occurs. It says, without going into where the levy ought to be, it only says, other than those services specified in the negative list, provided or agreed to be provided in the taxable territory. Now, what is the taxable territory? Very clear, you go through the guidance note, it says that taxable territory is India, Jammu and Kashmir is out, and I don't even need to do that because I need to look at section 1. Section 1 itself will tell me that it's an act which applies to India. It has no application per se to Jammu and Kashmir. If it has an application only to India, then what it also tells you is that it has no application outside the country. It is unlike the Income Tax Act, it's unlike the IPC, where certain provisions have been made applicable to companies even situated out of the country, individuals situated out of the country. This is not one of those acts. That being the situation, can you, by way of rules, and that is, I think, something which Jitendra will dwell upon while we go through the rules, and I'm not saying that what we are going to say now and what we are going to deal with is conclusive. I'm sure you will have lots of things to say. I'm sure you will have lots of questions. But to me, as I read the rules and as I go through the rules, there does appear to be a lacuna. There does appear to be a case for the department, the service tax department, to go against people, and I do see a situation and a way out of these scenarios which will play out. So we have, fortunately what we had done was that we had sought Ashit Bhai's help in it, and we had said that if there are any queries which have come from members, then to pass on those queries so that we can address it. And what we also found was that it was very useful. All these questions which have come to us, by and large, we've been able to cover all the rules beginning from 3 until 14, and we've been able to see a gamut of all these rules. I think there were some 15 questions which have been sent out. Too short a time really for us to deal with 15 questions, but we have picked up 8 of them, and Jitendra will deal with all the 8 threadbare. Certainly, we'll entertain after that also if there are certain questions, and if time permitting, we'll deal with them. But for the moment, I will leave the floor to Jitendra and ask him to take it forward, and we'll see how it progresses. Thank you.
Good evening, friends. Well, as Naresh Bhai rightly pointed out, Section 66B was introduced with effect from 1st July 2012, and the whole term taxable territory was given an undue importance. Prior to, am I audible now? Yeah. Prior to 1st July 2012, the whole idea of levying service tax was never on taxable territory. However, as Naresh Bhai rightly pointed out, Section 1 of the Finance Act itself always made it clear that service tax will be levied in India, and of course Jammu and Kashmir was out. Then came a need that since the whole viewpoint was on taxable territory, there were certain rules that were required to be enacted to ensure that the place of provision, and that ensured that the place of provision of service rules, as we call it POP rules or POPS rules, were enacted. The export of service rules and the import of service rules gave away, and now we have from 2012 the POPS rules, or I may just refer it as POP rules. Now, since the rules are from 2012, I'm sure everybody would have by now gone through the rules time and again. I won't be wasting too much time of the audience over here to just dwell too much into what the rules are. I'll just quickly run through each and every rule. And while going through the rules, we'll just touch upon certain illustrations that are provided in the education guide to understand the rules well. And thereafter, we'll touch upon the illustrations that were forwarded to us by Ashit Bhai, and we've picked up 8 out of the 15 illustrations, and then we'll move on. If time permitting, we can even touch upon various other questions if there are any. So, as far as the POPS rules is concerned, there are around 14 rules, and The rule 2 definitely deals with a lot of definitions which deal with what is a permanent establishment, fixed establishment, recipient of service. We will touch upon the definition as and when the rule requires. Here in this slide, we have just given a gist of rules, and along with it, in the second column is where the actual place of provision of service will be. Now, rule 3 is the rule that we generally call as the default rule, which basically says that the main rule 3 is applied when none of the other later rules applies. This has its color from rule 14. In other words, if a service is not covered by an exception under one of the later rules and is consequently covered under this default rule, then it is very important to note that the receiver's location will determine whether the service is leviable to tax in the taxable territory. Wherever the receiver of service is located, that is going to be the place of provision of rule. If it is outside India, so be it. If it's outside India, there won't be. If it's outside the taxable territory, there won't be any service tax levy. If it's inside the taxable territory, this levy will follow. The principal effect of the rule 3 is that where, as I said, where the location of receiver of a service is in the taxable territory, such service will be deemed to be provided in the taxable territory and service with tax will be payable. And if the receiver is located outside the taxable territory, no service tax will be payable on the said services. As an example, over here we have just, as provided in the education guidance note as well, there are 4 companies that we have stated over here, where ABC is a service provider, PQR is a service receiver, which are in the taxable territory. Then in the non-taxable territory, we have DEF, which is the receiver, and XYZ, which is a service provider. There are 3 different types of illustrations that we have just given over here. In the first illustration, if we say company ABC is providing service to PQR, who is the receiver of service, and both are located in the taxable territory. If at all this service falls under rule 3 and is not categorized under any other rule, then of course it's going to fall under rule 3, and since the location of service receiver is in the taxable territory, the service will be taxable to service tax. If we look at the second illustration, with the same service, where if ABC were to supply the same service to the recipient, that is DEF, and DEF is located in a non-taxable territory, the provision of such service is non-taxable because the receiver of service, that is DEF, is located in the non-taxable territory. That's what rule 3 makes it very clear. Now, if you look at the third scenario, this says if the same service were to be provided to PQR, located in the taxable territory, by an overseas service provider, that is XYZ, the service would be taxable since the recipient is located in the taxable territory. However, as we all know, the service provider being out of India, the reverse charge mechanism will kick in and the service receiver will be liable to pay service tax, which we also call as the tax shift. There are certain more examples that just we have worked out on giving the basic interpretation of rule 3. Suppose if the head office is in the US, the head office in the US, which we call it an HO, and the branch office is in India. Service provided in India and providing service to a service provider in India and providing service to a branch office. The contract for the said provision of service is between the US and the Indian service provider. Consideration also is received from the US HO in convertible foreign exchange. What is the place of service? Under rule 3, if the service falls under rule 3, the place of provision of the service is the location of the service recipient. Definition of location of service of recipient is defined under section 2(1)(d) of the place of provision rules. Location of the premises where it has obtained centralized registration. If not, then the location of the business establishment. If service used at a place other than business establishment, then it would be a fixed establishment. If service used at more than one establishment most directly concerned with the use of service. In the above example, as we have seen, the place of recipient cannot be either place of registration since the HO is in the US. Place of recipient also cannot be the business establishment since the service utilized at the place other than the business establishment, that is the branch office. Therefore, subject to the said service not falling under 4 to 6 and rules 9 to 12 of the POP rules, service recipient is going to be the branch office as it is the fixed establishment. It it would be very important over here to understand what is the term fixed establishment, and as has been explained under the education guide. The fixed establishment under the education guide is described as a place other than the business establishment, because of course we only can have one business establishment. Such place is characterized by a sufficient degree of permanence and suitable structure in terms of human and technical resource to receive service. It's been clarified that temporary staff for a short visit cannot be a fixed establishment. Suppose if we have people coming into India, staying in hotels and just doing a management service and just going back, that cannot be defined as a fixed establishment in terms of the education guide. However, it has been made clear a branch office would be covered under the term fixed establishment. So as we rightly saw in the earlier illustration, the branch office was receiving the service over there, and therefore since the BO was in India, the taxable, which was a taxable territory, the service tax was to be levied.
Sorry. While, since we are on this topic, an interesting question which comes to my mind is this. The manner in which the guidance note has gone about it, it is clearly a situation where the department has left with itself a huge margin to go after people. What is, how really does one deal with issues like sufficiency of, what is the term?
Permanence.
Okay.
Permanence service.
Yeah. So can we just go back?
Yeah, sufficient degree of permanence and suitable structure.
Yeah. Now, so sufficient degree of permanence and suitable structure. Now, something as vague as this, and the department thinks, that there is enough amount of clarity, then I'm sorry, I don't think so, because Jitendra gave an example of someone traveling to India from out of the country, doing some service, going back. We all know in income tax also we have situations wherein people there are services which are provided. So we have section 9 in income tax, and there are ways and I mean there have been litigation galore on that provision. Even after Ishikawa Jima issue has not settled, you had a Vodafone. Post Vodafone also, I can tell you that issue is not settled. I had a matter in the High Court a couple of weeks back, and we are yet all grappling with the same issue. Now, I really don't think that in a provision of this kind, issues will get settled, and as the guidance note has very vaguely put in that. For something of this kind, what is required to be shown is sufficiency of permanence. Now, what is the meaning of sufficiency of permanence? Let's say I am a foreign service provider. I come into the country. I stay here for a week, or I stay here for 15 days at a hotel. I am the only person who is required to provide that service, so I don't need 10 other staff to provide that service. You require a human element for the purposes of providing that service. I am the person, I come into the country, I am good enough to provide that service. I do so for 15 days and I go away. Now, I do this on a regular basis, so every month, 2 months, I come into the country, I provide the service and I go away. Will someone tomorrow say that this I have established, or the department tomorrow if it raises, will the department not raise a question that I have a business establishment or a fixed establishment in India? Is there now a sufficient amount of permanency by the fact? Let me again narrow down this to say that I come here every 15 days. So I stay in a hotel over here, and I tell that guy that look, I am going to come here every 15 days. You should therefore have a room for me. I will come, 15 days I will stay, I will go away, and I will pay you for the 15 days. It is as good as my office premise, because I don't need otherwise any other place. I come, I stay, and from where I stay I can provide that service. Do I meet with all the criteria that the department has provided in the guidance note? I mean, these are questions which will arise. And I don't know, maybe it is fortunate that until now, the department has not started any proceeding of this nature, or that people have been complying and suddenly everyone has become very compliant, because this is something which has come out in 2012, but until now we don't see any movement on any of this. And I'm sure with GST coming in, you'll have lots of issues which will come in. But then the question will be, which state? You provide this service in Maharashtra, or someone goes and provides a service in Tamil Nadu, and he does that on a 15-day basis. He goes there on a 15-day basis. Now forget people coming from out of the country into India. Why can't you have a situation where someone from Maharashtra travels to Tamil Nadu, and every 15 days he does that, and you have those type of people, you have those kind of services being provided? Then will questions not arise on from which place is this service being provided, and therefore which state ought to get prominence and which state ought to get its share of pie? It will.
Being on the same rule, there is a very interesting example. I just thought I would place it for consideration of everybody. Suppose, and it's a very common thing that keeps happening. Country A establishes a subsidiary company in India. Service agreement with the Indian subsidiary is to provide promotional and support activities to customers in India. Promotional and support activities involve marketing, demonstration of various products of the business establishment A to potential customers and dealers in India. Agreement states that subsidiary is not an agent or of business establishment of A. Also, subsidiary has no relationship with the potential customers, dealers, other than demonstrating products. Now, post the POP rules, which is going to be the place of provision, right? We have rule 3 over here. The rule 3 clarifies that the service recipient is going to be the place of provision, and the service recipient over here ultimately is going to be the country A, which is in the non-taxable territory, and the service tax will not be leviable. In one of the few decisions that we have on this subject today, the AAR authority in the case of Tandas Flooding has given AAR ruling on similar basis, where the AAR authority has said that since in terms of rule 3 the recipient is located outside India, this tax liability will not come. However, there was a case which I would like to just share with everybody over here that I was arguing before the tribunal, which pertained to the pre-POP era. In identical facts, there is a difference of opinion between the two members of the tribunal, where one of the technical member has taken a stand that since the services like promotional services, support activities which involve marketing, demonstration of various products are services which are ultimately being consumed into India, therefore why not it can be said that there is a service that is being provided, your foreign company being a company which has got no establishment in India, there is going to be a reverse mechanism that kicks in and you pay service tax. The issue is still pending before a third member. However, that issue pertains to the pre-POP rules. So even today there can be such a scenario where the department, in spite of there being rule 3 which is so clear, might tomorrow come and take this kind of a stand that services are ultimately being consumed into India. We'll have to see what the definition of the recipient says, and therefore the department might contend tomorrow that since the services are being consumed into India, the tax liability would be in India. Well, with this we move on to rule 4, where the place of provision for service is based on the performance. The rule says that the place of provision of following services shall be a location where the services are actually performed, namely services provided in respect of goods that are required to be made physically available by the service receiver to the service provider in order to provide the same. Provided that when such services are provided from a remote location by way of electronic means, the place of provision shall be the location where the goods are situated at the time of provision of services. Clause B says, services provided in conjunction with supply of goods under another contract by the service provider, and clause C says services provided entirely or predominantly in ordinary course of business in the physical presence of an individual represented either as a service receiver or a person acting on his behalf. Two major criteria over here, that the goods on which the services are to be provided have to be physically made available by the service receiver, and second, the service receiver should be predominantly in ordinary course of business, be physically present at the time of provision of service. Now, what kind of services would fall under the category of Rule 4? As per the education guide, there would be repair, reconditioning or any other kind of work on goods, maintenance of any goods, storage, warehousing, courier service. However, it clearly says it will not cover services where supply of goods by the receiver is not material to the rendering of service, where a consultancy report commissioned by a person is given on a pen drive belonging to the customer. The goods are not being provided. Certain services like cosmetic or plastic surgery, beauty treatment services, personal security service, health and fitness services and like, that would require the presence of the receiver, because I cannot afford to go and have a beauty treatment service without me being personally present. I have to be present in the beauty parlor for the service to be rendered. So therefore, these are the like examples where these kind of services will fall under category 4B. And what is stated in the first bullet, which comes to repair, reconditioning, will form under category 4A. Moving on to Rule 5. Yep.
In case of software,
Yeah.
which will be the investment cost? There is a software is used in India. There is some problem with the software.
Yeah.
Or modification or something like that. The consultant is in foreign country.
Yeah.
He logs into the computer of the service. There's some changes in it.
Okay. In that event, the relevant rule that would kick in would be
You may,
of course, only, right?
you may have a, yeah,
Section
Rule 4.
Rule 4.
So we can tackle it now, because if you look at Rule 4, software is good. That there is no doubt, because today now you have State Bank of India, you have TCS of the Supreme Court, both of them have held that software is good. So therefore that we have no issues with. If you look at Rule 4 in the manner in which it is couched, now Rule 4 says, services provided in respect of goods that are required to be made physically available by the recipient of service to the provider of service or to a person acting on behalf of the provider in order to provide service. So, Rule 4 is a performance-based rule. In this case, while the receiver will have to make the goods available to the service provider, that there is no doubt about it. However, while we will fall within sub-rule A, we will also be covered by the proviso, because here it's a situation wherein the service is being provided from a remote location, though the goods have been made available, namely that the software has been made available, but the service is being provided through a remote location. And in such a scenario, what they have said is that it will be the location where the goods are physically. Now in software again, there is a debate, and it can only be a debate, let me tell you, that we may all want to say that no, for the purposes of software, it is ultimately the location is not here in India, the location is abroad. But in reality, when a service is being provided on a software by remotely connecting onto your computer, it's not as if it is not a situation wherein the software is actually physically taken out of the country and taken there. He actually will remotely log onto your computer and he will actually work on the software. So the location of the software will be in India. So this argument to say that the software is actually out there and the work is being done there will not work. So to me what will apply, I mean I'm absolutely on a prima facie view, what I can see is that what will apply is Rule 4. And applying Rule 4, the location at which the software actually resides, which can be anywhere, so it's whether in Mumbai or anywhere else, that will be the location where the service is being provided, and that will be taken as to be the place where this actually, in that sense, while you have this situation of someone sitting out of the country doing this will also play out in a GST type situation. You will have someone, let's say, sitting in Bangalore working on your software in Bombay. Absolutely possible. So the question will be, where is the service being provided? or received.
Actually, there is one illustration or a case study that we have made on this issue. We will come to that and automatically the answers would flow from there. When it comes to Rule 5, it's the service related to any immovable property, and it very clearly says that place of service would be where the immovable property is located. So therefore, any service which is provided directly in relation to an immovable property will get categorized in Rule 5. There is a very interesting case study that we have inserted in the slide in terms of immovable property, where there are certain transactions as to how they have been entered, which we will just dwell upon a bit later. But the basic structure of the Rule 5 is that any service that is being directly provided in relation to an immovable property would fall under Rule 5, and the place for provision of the service would be the place where the immovable property is located. So there is, that's how Rule 5 is. And let's move on to Rule 6 on that. Rule 6 talks about place of provisions relating to events. Now we have various event management companies, cultural companies, there are artistic events that happen, sporting events that happen. What would be the place of provision in those situations? So the Rule 6 clarifies that the place of provision of services provided by way of admission to or organization of a cultural, artistic, sporting, scientific, educational or entertainment event, or a celebration, conference, fair, exhibition or similar events, and of services ancillary to such admission shall be the place where the event is actually held. Now, from today the Indian Premier League is starting, and I'm sure most of my friends who are sitting in the room would be a fan of one thing or the other. Some time back, there was this view taken by the Service Tax Department as to why service tax should not be levied on various services that are being provided by the BCCI in terms of the Indian Premier League. There were various arguments that were floated in this relation, where they said that no, there is no service being provided. It's not an event, it's just a gala entertainment event for the entire world at large. But now, with place of provision rule, and Rule 6 in particular, which very clearly says that any event where it is being held would be the place of provision. I think the IPL would get covered in Rule 6 now, in terms of the clear-cut definition that has been provided in terms of Rule 6. The illustrations that we have carved out for Rule 6 are: a management school located in the US intends to organize a road show in Mumbai and New Delhi for prospective students. Any service provided by an event manager or the right to entry will be taxable in India. Or if you take the contrary, Indian fashion designer firms host a show in Toronto, Canada. The firm receives services of various Canadian event organizers. The place of provision of this service is the location of the event, which is outside the taxable territory. Any service provided in relation to this event, including the right to entry, will be non-taxable. That's what Rule 6 clarifies. Moving on to Rule 7. It says place of service when provided at more than one location. Now this is one...
Sorry, if I may just interrupt you in between. If you can go back to that slide. There's just a question to you. That, while you said that in your second illustration you're saying that it's an Indian fashion designer which hosts a show in Toronto, and the firm receives the services of the Canadian event organizer. The place of provision of this service is the location of the event, which is obviously outside India. If you go strictly by Rule 6, no tax is leviable. But don't you think Rule 7 would come into play in this situation, in light of the fact that if you today, what does Rule 14 say? Rule 14 actually says that you have to go sequentially. And if you have a situation where you find that a service is capable of being, in that sense, capable of falling into rules, and as I see it, it's a possibility in this situation, and an absolute possibility that you can say that it falls under Rule 6 and also falls within Rule 7. So if I take Rule 7, would you not say that, the Indian fashion design, who wants to actually host should pay the tax?
Well, in this situation, let's first go to Rule 7 and I'll again come back to this slide. Rule 7 basically says that where any service referred to in Rules 4, 5 or 6 is provided at more than one location, including a location in the taxable territory, its place of provision shall be the location in taxable territory where the greatest proportion of the service is provided. So what is condition precedent for you to fall under Rule 7? The condition precedent is that there has to be some service that is provided in the taxable territory. If you look at the earlier illustration that I was talking about, though it's an Indian fashion design firm, it's hosting an event in Toronto, the services that are being received are from a Canadian event organizer. The place of provision, therefore, it is said is in terms of Rule 6 is the location of the event. In this case, there is not a single service that is originating from India. If at all we modify this illustration to say that the Indian fashion design is hosting a show in Toronto and it is taking the help of various fashion designers in India to design the outfits. There are certain event organizers from India who are strategizing the entire event, and then the said event is outsourced to a Canadian event organizer, and the Canadian event organizer is executing the event. Then, as to what Naresh said, Rule 7 will kick in because some part of the service is being provided in the taxable territory of India. In the illustration that we are talking about, since not a single service is being provided in the taxable territory, the Rule 7 will not kick in and Rule 6 will be the right rule where the service is going to get classified.
But the proportion of service in India will be minimum.
That is where I'm just coming to. Before we started our presentation, Naresh Bhai was talking about there are a lot of lacunas in this rule.
Greatest proportion means in terms of value.
No. That is what was the situation prior to the POP rules kicked in the export of service rules, where it said that whatever is the service that is being rendered into India would be the value. Over here, if we read Rule 7 minutely, what it says where service is referred to in Rules 4, 5 or 6 is provided at more than one location, including location in taxable territory, its place of provision shall be the location in the taxable territory where the greatest proportion of service is provided. So by here, the department might very well take a stand that this rule is not to tax the service on pro rata basis or on the proportionate basis. By this rule, what the legislature intends is even if 10% of the rule of the service is provided in India and 90% is abroad, out of that 7% is in Bombay, 3% is in Ahmedabad, the Bombay Commissionerate will have the jurisdiction to tax the entire 100% of service. The rule, make no mistake, does not talk about taxing in proportionate basis. It only says that the provision shall be the location, the place of provision shall be the location in the taxable territory where the greatest proportion of service is provided. So therefore, even if 10% of service is provided in India, and out of that,
It's for service or it's collectively?
it's for the entire taxable service. It's not for.
There will be a number of services.
There would be a number of services. Correct. For an event, there would be number of services.
The question, and I think a very valid and a relevant question here. Question is, let's say, you have 2 or 3 different services being provided for the same event. Okay, so event by itself, in that sense, is a service.
Correct.
We have said that, event is not taxable.
Yeah.
But in your second example which you gave, saying that you could also have a situation wherein certain designers from India are doing, so you can have in that itself you can have 2 or 3 different services.
The answer to that would be, in my opinion, we'll have to look at the services that are being rendered in India and what proximity they have with the services that are being provided outside. Suppose if there are 3-4 different services that can be categorized in various silos, then it cannot be said that everything that is being provided as a complete event would be taxed in India. For example, in foreign or in the non-taxable territory, there is a complete event that is being taken care by an event organizer. At the same time, there is a service that is being taken off a fashion designing firm to have a fashion designing concert or to have a fashion show over there. in that fashion show, the dresses that are being used are by the Indian fashion designers, and surveys of Indian fashion designers are taken. Can the department then say that though the services taken from India are only having a proximity towards the fashion show, I'm going to take the entire event as a taxable service? To my view, the answer would be no. Because if we can categorize the event separately from the fashion show, and fashion show is a different service per se, then we can say only that portion of service would be taxable in India. But to say that the entire service of fashion show would be taxable, it cannot be said that since the fashion designer service costed only 7% or is only forming 7% of the entire value of the fashion show service, I'll only tax 7%. That is not the intention of Rule 7. That was what the point that I was trying to make.
The computation can be this also. The designer who has provided service in India as well as abroad.
Yeah.
Each service, what is the proportion? Whether each service in India is maybe valued 10% and greater proportion is abroad.
Yeah.
Then even this 10% won't be taxable.
Well, you're right. There can be this kind of an interpretation. However, if we go by
No, it says each proportion. It's not saying all service will be.
correct, no, that's it.
I take your point. So and if you look at the guidance note itself, while you were making the point, I was looking at the guidance note also. If you look at the guidance note, it says this rule is, however, not intended to capture insignificant portion of a service. Okay. What is the meaning of the term insignificant portion of a service? For all I care, that 10% could be a very important factor without which your event will not be successful. Is it insignificant? Merely because the value is 10,000 as against a higher value there? If your event was to fail, and in the example that we are looking at, if your event is about everything to do with fashion, and if the dress does not go from here, that's it, your event is over. So even if the more so-called significant portion is actually out of the country, but so-called insignificant portion that we are talking about, which is 10,000 rupees within the country, if this dress does not go there, it is as good as finished. And so this significant, insignificant, and that's the reason I began by saying that there are lots of things that one needs to look at, and it is very easy for the department to put it in the guidance note and say that an insignificant portion is not said to be taxed under this rule. The question really is, what is the meaning of the term significant and insignificant? And I actually am not putting the department to any test, because this ultimately will have to be decided on a case-to-case basis. What is significant, what is insignificant will not in every situation be decided by either the value, though that can be a very good measure. That can be a very good measure to say that it is significant or insignificant, but depending upon a situation to situation, significant or insignificant will also change according to the nature of the service.
And in fact, even if you see the guidance note, in guidance note there again is an illustration provided, where they say that an Indian firm provides technical inspection and certification service for a newly developed product for an overseas firm. The testing 20% happens in Maharashtra, 25% Kerala, and 55% of the testing is happening international location, that is Colombo. In terms of the place of provision rules, Rule 7, it has been clarified that notwithstanding the fact that the greatest portion of service is outside the taxable territory, the place of provision will be the place in the taxable territory where the greatest proportion of service is provided. That is in case of Kerala. So if at all it would have been the intention to only tax the portion that has been taxable or that has been provided in India, they would have specifically had that kind of a clarification in the rule. Since rule, and as you rightly said, the term its proportion has to be dealt service-wise. It cannot be that if there are 4 different services, you can just bucket them into one service and say every service would be taxable in India. No. But then, in certain situations, it becomes impossible to have a dissection into what services are being performed. At the end of it, everything looks like one service as a whole. So therefore, in that situation, it would be quite difficult for us to distinguish as to what is being performed in India is directly proportional to which service that is being performed in the overseas territory.
I think,
10% will not be taxable.
No, it will be.
No, it will be.
It will be.
which is, I think, and this is where the problem lies. This rule, in the manner in which it is couched, you can have a situation, so here we are talking about 55, either we can stay with this example or we can take a different example and say you have a situation wherein 80% of your service is outside the country. You have 20% of the service within the country. Now, we spoke about significant, insignificant. The question about significant, insignificant, I will keep it aside for the moment. Actually, the question that one should advert to is this, that tomorrow if it is decided that the 20% is significant and therefore the 20% is what decides the fate of the entire 100%, will it yet be said that the 80% also ought to be taxed? And I have a problem with that. Why do I have a problem with that is that you have brought about this rule. Primarily the reason for you to bring about the rule is to see to it that in a GST sort of scenario, you don't have a problem with, you don't run into difficulty with which state ought to tax, and therefore you have said that the greatest proportion of where the service has been provided. While I am saying that that itself is a dispute, what is the meaning of the term greatest proportion? Like you rightly said, is it value or is it anything else? But maybe let us for the moment say that, we stick with and we stay with value, and we say that it is the value which ultimately decides, because that is a good measure. Now, having said that, so far so good. Insofar as domestic transaction is concerned, maybe this is a good way of deciding. But insofar as an international transaction is concerned, where your 80% of the service is actually outside the country, the question one needs to ask is this, that what was your stated position qua the Act? The Act says that there will be a service tax which you are required to pay in respect of service provided in the taxable territory. Okay? What is the taxable territory? India. It does not even include Jammu and Kashmir. Forget anything outside the country. If that is your taxable territory, then how can you now come out with a rule which says that, so what? I am now going to tax something which is otherwise outside the country, but by way of this rule I am going to say that since 20%, which according to me is an extremely significant portion, which has been provided here in the country, now in respect of that I will tax everything. Globally, I will tax everything. I can yet understand them saying that I will tax the 20%. No issues, because the 20% is within the taxable territory. But what about the balance 80%? And this is where I think there is a constitutional overreach, because you have now gone beyond the provision of the statute, namely 66B, by way of a rule. You as the delegatee cannot go beyond what the statute provides. You should stay within the statute, and if your statute says taxable territory, tax the 20%, don't tax the 80%. This is where, according to me, it's in that sense an overreach by the executive to, and they are the ones who are now legislating going beyond the provision which is 66B.
I'm sure these kind of issues will definitely come to light once the service tax demand start coming in on these issues. But as Naresh rightly said, the whole purpose of the jurisdiction to levy tax is not there in these cases. You cannot levy tax on 100% value. I understand if the tax is levied on the 20% value. You cannot go and exceed your jurisdiction by levying tax on 100% when 20% has been provided in India.
There can be situation of double taxation.
Double taxation. Correct. And in fact, this rule again is contrary to Rule 13 itself, because Rule 13 gives powers to central government to ensure that there is no double taxation.
And absolutely you're right. Look at the guidance note. Like Jitendra rightly pointed out, there is a case for you rightly said double taxation. He pointed out the rule which goes contrary to that. Look at the guidance note. The guidance note also starts and ends with that. What does it say? It says that this is to avoid two scenarios. One, that there is something which ought to be taxed ought not to go untaxed. So the department, namely the Indian government and the Indian Revenue Department ought not to suffer. So far so good, I have no difficulty with that. and no quarrels with that. The other part of it, where it says that this is also why we have brought these rules, is also to see that we avoid double taxation. Now by this rule they are doing exactly the opposite. So this rule is contra section. This rule is contra rule 13.
Now, in fact, we have one more rule now, rule 8.
Point Naresh bhai, I would say there is a lot of scope for designing the transaction before it is actually.
Yeah, absolutely.
That you are right. That
Structuring of transaction would have a very important role for rule 7.
Look from that perspective for our client.
Yeah. No, absolutely. Why?
Such a
Absolutely.
transaction,
Absolutely.
they should do it very clearly to take care of such things.
Yeah, no, I agree.
Quantify everything, put it in black and white.
No, put it in black and white, and at the same time, as you rightly said, structuring is the name of the game in terms of these kind of rules are concerned. Because nobody would want to provide service in India which is going to be having some implication of ₹1,00,000 and then have an implication of running in crores of rupees because the service provided abroad is a very large service. Nobody would want that to happen.
It is, the project can be split into 2 parts, 3 parts.
See, I agree with what you are saying, that that is that's one of the mechanism available, and we do it all the time. I mean, in our office we have scenarios where we as tax professionals sit in a negotiation and we see to it that we drive our point home. But let me tell you that in a commercial negotiation, not always what you say goes home, because while you are talking from the tax perspective, you will have a corporate team which will talk from the corporate perspective. You will have a commercial team which will say that, oh boy, what are you talking about? Mera paisa lag raha, who are you to dictate terms to me? So it's not always as easy as what, and so practicality at that point in time takes over, and people then look at tax and say, okay, we'll deal with it when the situation arises. So that it is an answer, but it is not a complete answer. A complete answer may lie somewhere in between.
Now, as we look at Rule 8 again is a rule that I feel is very curiously drafted. It says place of provision of service, where the location of service provider as well as that of a service receiver is in the taxable territory, shall be the location of the service receiver. So therefore, where in terms of Rule 8, the place of provision of service, where the location of the provider of taxable service as well as that of the recipient of services in the taxable territory shall be the location of the recipient of service. Now what happens, as an illustration that we have pointed out, a helicopter that belongs to Pawan Hans, which is in India, develops a technical snag in Nepal. Nepal does not form part of the taxable territory. Engineers are deputed from Bangalore to undertake repairs at the site in Nepal. Technically speaking, the service has been provided abroad. There has nothing to do with India. In terms of what Section 1 read with Section 66B says, there should not be any tax. But in terms of this rule, the mischief created by this rule is this, since both the parties, the Covenants and the Hindustan Aeronautic Bangalore are in India, it's going to be taxable. Now, if I may ask a question, what jurisdiction does the department has in this kind of a case where the service has not even been provided into India? Merely because the recipient and the provider are going abroad and providing a service abroad, how does it give jurisdiction in terms of what is clearly stated in Section 66B? 66B says if a service is provided under a taxable territory, then tax is going to be levied. Where is the taxable territory in this case then? There are various other illustrations that we have taken in the later slides that I'm going to dwell upon. But as Naresh was saying, these are the lacunas that are still there in place of provision rules. Though this rule has been enacted in 2012, unfortunately, nobody has challenged them. Hopefully, sometime later when the demands are going to keep flowing into these rules, and I'm sure they will, somebody will definitely move the higher courts and challenge the virus of the rule.
Yeah. To me, there are a number of permutations and combinations insofar as the argument is concerned. One of the argument which may work in the department's favor is that ultimately what are we looking at? We are looking at a situation wherein, let's go back to the guidance note and how it begins. It begins by saying consumption-based tax. Okay, it's an indirect tax. All indirect taxes are consumption-based tax. So is service tax a consumption-based tax. Good. The argument here may be against the assessee will be that it is just the goods which are located outside the country. Okay? Who does the goods belong to? Who is the person carrying out the repair? Again an Indian party. Who is therefore consuming the service? It's not anyone in Nepal. The consumption is, while the service in reality, in physicality is happening outside the country, but the consumption of the service, so therefore, and this is where I think, the thought process has to take a different route, because when it is goods, it's a very clear case to say that, oh, this is the place where the goods have been manufactured. Insofar as the service is concerned, you can have a service being performed at a place, but the provider and the recipient both could be in a very different jurisdiction, and therefore the consumption, both the provision and the consumption of service could be very different at very different jurisdictions. In this scenario that we are looking at, it is the consumption which happens in India. If it's a consumption-based tax, if I am going to argue in court to say that, oh, look, you said it's a consumption-based tax, then they will turn around and tell me that exactly what I am trying to say. It's a consumption-based tax. You have consumed it here in India, and that is the reason for me to bring this rule to say that you have a provider, you have a recipient, both are in India. If both are in India, there is no question of saying that this will be non-taxable. This will be taxable where the recipient is, namely Rule 3 applies.
In such situations, let's say the service provider has not gone for centralized registration.
Correct.
And the rule says that the location of the service receiver is important.
Yeah.
What jurisdiction do you follow?
Which
Where-
is-
Where do you get the registration? Where do you file your returns?
So which is where your location of service provider, the definition of location of service provider plays an important role. So you may have a head office and you may have branch offices. It is one of the branch office which gets, so it can either be the head office or it can be one of the branch offices. So the office which actually receives the service.
Where it is basically consumed. If you see the definition provided under Rule 2H, location of the service provider, it says where the services are provided by first a business establishment, if not a business establishment, then a fixed establishment. If it is provided by more than one, if there are more than one fixed establishments, then which establishment is directly concerned with the provider of service, and rightly so. And in similar manner, location of service receiver has been defined in 2I, which says the receiver's location will be determined if the location is his business establishment, if not his business establishment, then fixed establishment. If he has got more than one fixed establishments in India, then the establishment most directly concerned with the use of the service. So technically speaking, in this case, the service provider is Hindustan Aeronautic Bangalore. So Bangalore office of Hindustan Aeronautic will have the jurisdiction over in terms of the service tax authorities. Or if Power Hands is in Mumbai, then the Mumbai Commissioner will have the jurisdiction in terms of this transaction.
That is my question.
Yeah,
Let's say Power is in Mumbai.
Yeah.
Service provider is in Bangalore.
yeah,
Now the service tax liability is on the service provider.
yeah.
Okay, now where does he get his registration? When he got decentralized registration?
Correct.
Not under centralized.
Correct. So it's going to be in Bangalore. Because in terms of the rule 8, if we see, it shall be the location of the service receiver.
The service receiver is Power.
I'm sorry, then it's going to be Mumbai. Yeah.
So though the service provider is in Bangalore, they are not having centralized registration only for one particular service.
They'll have to.
So depending upon their customers.
Yeah.
Suppose, let's say he has got another aircraft.
Yeah.
When the customer is from Assam.
Assam.
he will have to-
I completely understand your point. It will lead to, if you're not obtaining for a centralized registration, it's going to be leading to an anomalous situation where you'll have to take registration all across India. But be that as it may, that's what the rule
Yeah,
says.
in a situation of this kind, you will, and see, this, today with the negative list being there, everything else which does not fall within negative list is taxable. So all such people it would benefit. So you're right, it is beneficial to have a centralized registration rather than to leave it open and then go to jurisdictions where you have no control. So tomorrow if you have ended up paying either less or more, if you have paid up less, no difficulty, we will follow you. If you have paid more, then you can forget your refund ever coming. So it is better to have a centralized registration rather than to leave it to this scenario.
In fact, one of the basic clarification given in the education guide is that in terms of taxpayers' perspective, the jurisdiction of field formation, which is relevant for compliance and registration for formalities, filing of returns, will be the location as determined in terms of the POP rules. Now, just 2 days back, I got a call from my client and he was telling me, Jitu, it's a very strange situation. I've got a centralized registration and I've got an ISD. I'm availing ISD credit over here. The Mumbai Commissionerate keeps coming to my office every 10 days and they keep asking me, how do you take that credit? How do you take that credit? No, I've got a factory in Surat. I've got a factory in Daman. I've got a factory in Bangalore. Even the authorities over there keep coming into my doors and asking me, how your ISD has taken the credit. What is the answer that I need to give in that? That's what I told him, that in terms of POP rules, if you see the education guide clearly says that POP rules is going to determine the location and which authority has the jurisdiction to come and question you. So the opinion that we gave him was, since your ISD is in Bombay, you are a centralized registration, except for Bombay Commissioner, nobody else can come and ask or question as to how this kind of a credit is taken and why this kind of a credit is taken. So this is what even the POP rules and the education guide clearly say, that in terms of your location, you will have to take, if you don't opt for centralized registration, so be it. Then wherever is the service recipient's location, you'll have to go and take separate registration over there. Like we have it in VAT. Like we have it in VAT.
Naresh, on your consumption theory, these services have been consumed in Nepal. The benefits of that services have been utilized by the owner of those services. Take the reverse, another example. A film star goes for a shooting of a particular film. The stylist of that particular film star is also from India. The service is to be provided, let us say in Dubai or wherever they are shooting that particular event. And the services is taken over there, it is consumed over there, the matter is finished over there. The consumption does not mean wherever the owner is located.
No.
It is, see, you are saying the consumption of the service is at a place where the service is rendered.
No, sorry. I have, in the scenario that we are dealing with, which is, Pavanans. In the Pavanans scenario, I would disagree with you, because in that situation, the consumption of service is not in Nepal. See, the consumption of service, the question will be the consumption of service is by who? And therefore, where is the recipient? In the Pavanand scenario. In the haircut scenario, the person, when he travels along with a Shah Rukh Khan and Shah Rukh Khan gets his haircut wherever it may be, in whichever part of the world, or he takes a stylist along and that stylist does whatever he has to wherever, then the consumption is by the person, because that is where the person is, and that is a personal service. In case of a beauty treatment, in case of a situation where a stylist travels along with you, he does whatever he does, all of those are services of personal consumption. In case of a Pavan Health scenario, it's not a service of personal consumption at all. So both are slightly different. So I'm not at all saying that the consumption in all scenario happens where the service recipient is located. I'm not saying that, because the service recipient could be in different jurisdictions. In that situation, in case of a personal service, every jurisdiction that he goes to, that will be the place of consumption. But in a situation of the kind that we are facing, the facts of the matter will decide where the consumption actually happens.
And more so, if you see the charging section itself, of course, we all know that it's been held time and again that the rule has to take color from the charging section. It cannot go beyond that. What does the charging section say? The charging section says there shall be levied a tax provided or agreed to be provided in a taxable territory. If we look at the true sense of that, where is the service being provided? It's being provided outside the taxable territory. So therefore, in my view, in certain scenarios, Rule 8 will completely be ultra vires of the charging section itself.
But Jitendra bhai, can't the department stand with that there is a deeming fiction under the PPSR, I mean POP, because when we read as to be a taxable territory where the services provided or agreed to be provided, the place of provision itself determines the services provided or agreed.
But then the deeming fiction cannot be such that it overrides the provision of the charging section itself. So therefore, whenever there has to be a deeming fiction, it has to flow from the charging section.
The same situation, probably you are...
You are right. Absolutely. So therefore the question really that will again fall for any court's consideration is that what is the length and breadth of a deeming fiction? And the length and breadth of a deeming fiction cannot go beyond the charging provision. If the charging provision says taxable territory, you now can't buy a deeming fiction, take it to,
on the taxable territory. Then there was no purpose of having a provision of 66B in the first place. And at the end of it, we have to...
Therefore, actually, if you ask me, they have cut off their legs. If the provision of 66B was not changed, and
the 66 original.
So and they had retained the original 66 with the rules, we could all have been in trouble. But because they chose also to change the 66B and then bring about the rules, that all these problems are arising.
Just to add one more, sir, if you see the place of provision under which section they are notified, they have a specific provision to say even if the services are deemed to be provided outside India, merely because it is having extraterrestrial jurisdiction, it cannot be deemed to be ultra-virus. It won't be treated as to be ultra-virus. That provision is also there. So
no, but that proviso, which proviso are you talking about?
Section 60.
Yeah.
Look at. We'll move ahead. Once we get onto this, then we'll come back. I'll just quickly wrap up the rules because there are 8 very interesting case studies that we have prepared. As far as Rule 9 is concerned, the place of provision for the following services shall be the location of the service provider. Services provided by a banking company or a financial institution or a non-banking financial company to account holders. Telecommunication services provided to subscribers, online information and database access or retrieval service, intermediary service, service consisting of hiring of means of transport up to period of 1 month. Now everything over here is quite clear except for, I think, in terms of intermediary services, there are certain illustrations that have been provided. And in terms of the intermediary services, what it says is, intermediary means someone who arranges or facilitates provision of service between two persons.
66C.
Provision of main service on his own account is excluded. Therefore, intermediary cannot have his own individual service. It has to be a facilitation. Intermediary with respect to goods and with respect to service. Commission charged by intermediary with respect to goods is excluded specifically from the definition of term intermediary. Characteristics of intermediary: cannot alter the nature or value of service. He cannot have a value addition. Value of intermediary service is distinguishable from the value of the main service. It should not be a case that the person is providing the service completely and he says that I am an intermediary. That will not fall under the category of the term intermediary service. Services provided by an intermediary is distinguishable from the main service. For example, we have travel agents, we have tour operators, we have commission agents, we have recovery agents. We'll move on to the next one.
Yeah, just to answer Narendra's point, I think, his references to 66C and 66C2. I'll just read that out. This is with regard to determination of place of provision of service. Any rule made under subsection 1 shall not be invalid merely on the ground that either the service provider or the service receiver or both are located at a place being outside the taxable territory. This is very different from saying that the service is actually, see the recipient, the moment you say that it is a consumption based tax and the consumption is outside the country, I am not talking of the location of the service recipient or the service provider, I am talking of a situation where the consumption is outside the country, and which is where I think this entire issue will revolve around. And therefore the problem that I have with the term taxable territory in 66B and the rules in the manner in which they are framed. So it's a matter of argument. There will be lots of argument on this. So we can open, this as and when it goes to court, and if anyone wants to challenge, this will become a huge thing. The question, you are right, how do you therefore read 66B along with 66C and the rules?
And more so, if we actually see, it cannot be said that every service that is consumed outside the taxable territory, if it has got some benefit accruing to a party in India, would be taxable in India. We had an example of the hairstylist and Shah Rukh Khan. At the end of it, Shah Rukh Khan has to come back to India. So the department will argue that his haircut that he had over there will have some benefit here also. He is going to show that haircut in India also.
Yeah. And why not? If he has a haircut tonight and tomorrow morning he lands in India, then the benefit is in India.
At the same time, for the Pawan example, we have to see the exact benefit Pawan is getting out of that. Pawan has a helicopter that is stuck in Nepal. It has to get its goods back. The immediate benefit for Pawan is going to be to get the helicopter started, just lift it from Nepal and get it back to India. So the immediate benefit of the service has taken place in Nepal. The main consumption of the service has taken place in Nepal. Subsequently, it cannot be said that because that service took place in Nepal, Pawanans will be able to give that helicopter and rent in India, and therefore the service is being carried out in India. That's the answer to 66C2.
That was exactly the point I was making. See, the service consumption and the owner of that service consumption are intermediary, you are trying to absolutely link the two.
I'll tell you why. And I yet have a problem with this theory. When you talk of consumption, you are talking of consumption qua someone. Okay? Who is that? Therefore, who is the person who is consuming it? That consumption is qua someone. Who is that someone that we are talking of? It is Pawanans. Okay, and that Pawanans is in India. So the service may be carried out anywhere in the world. Who is the person who is actually consuming it? Where is therefore the consumption? The consumption cannot be in Nepal.
An agent also being intermediate.
The consumption of that service therefore cannot be in Nepal. The consumption of the service is therefore connected with the person who is actually going to consume it. I can understand if...
That is correct, if it is rendered in a taxable territory. That logic would perfectly fit very
Why would it be different? Let me ask this.
Then you would say every activity which an Indian taxable entity performs anywhere in the world, whatever services it takes, it is the owner of that benefit of that services, so everything is taxable in India. That can't be. That's an absurdity.
No, there again, and therefore you have the Rule 8 scenario. See, the Rule 8 scenario is that you perform the service anywhere. If you have the recipient and the service provider in India, then the service, you have to pay tax on it. That is exactly what they say in Rule 8.
And trust me, tomorrow, even if you end up going before a judge, and if you read 66C2, and if he has an interpretation that yes, it's completely legible, he might even hold the constitutional validity of this rule. It cannot be said that merely because this is completely outside, the consumption is happening outside, it will definitely amount to an ultra-virus situation.
See, you cannot have a situation, you cannot go and argue before a judge and tell him that ultimately the service consumption is Nepal, so what if it is Pawanans,
Mumbai?
Who's going to pay me? This could be a very large transaction for which Pawanans pays me a few lakhs. and I'm going to tell the judge that the consumption happened outside the country, and therefore don't ask them to charge me tax. The judge is going to laugh at me. He's going to look at me and say, what are you talking about? You can't have a consumption which is disconnected with the person. Consumption is for a person. The person is in India. He's the one who's therefore receiving the service. When we talk of consumption, what are we talking of? We are talking of receipt of service. That consumption is nothing but the receipt of service. The receipt of service is by a person. The receipt of service is not by the helicopter. By what you are saying, the service otherwise would be consumed by the helicopter, but that's not what it is.
That is the main reason why I say when it comes with taxable territory, absolutely fine. But here you are trying to tax all transactions of your resident taxable entity.
Correct.
For the transactions done outside taxable.
Correct. But that therefore, the moment you say that service tax and the moment you agree with me that it's a consumption based tax, and I completely agree with the department. I have no other view on that. The moment you agree with that proposition that it's a consumption based tax, that is the answer. I mean, that's the answer. The moment is a consumption there, who is consuming? That is the next question which will come up. Because when you say consumption, who's consuming it? I'm very happy. Anything and everything which is ultimately consumed by your Indian entity has to be taxed. The moment it is a person, so had this been a helicopter which did not belong to an Indian entity and if it was outside the taxable territory, finished. The Indian government could not have done anything about it.
It would be something like consumer-based tax.
Yeah. There's an answer to that also. I mean, we can go into, see today,
No, it's not consumer-based tax. What we are basically trying to say is the consumption is...
What are we looking at? We are looking at two different rules where you can possibly fall. You're right. So what about rule 4? Because these are performance-based. These are goods. The goods are in Nepal.
Has provided the goods.
Absolutely. So I fall within 4. Assuming for a moment that I fall within 4. I also fall within 8. But service recipient and the service provider is in India. What do we do? Go to rule 14. The later shall prevail.
That's why. Or will always come prior to it. So.
No, that's the reason. 4 is not useless. 4 is not useless. 4 has its own. So in your software scenario, 4 is what would have applied. Your 4, it is not as if 4 is become redundant. It is just that in your mind, 4 is what applies. We are all forgetting that while 4 applies and there is no doubt about it, but at the same time you are at 8, which also applies. Because of the fact that the recipient and provider are both situated in India.
And that is the reason why we have rule 14.
And therefore you have rule 14. Absolutely.
To ensure that this kind of an anomaly is avoided. Okay, on rule 10, it's a rule on goods transportation service. The place of provision of service of transportation of goods other than by way of mail or courier shall be place of destination of the goods, provided that the place of provision of service of goods transport agency shall be location of the person liable to pay tax. So there are two separate scenarios. The first one deals with the service, the second one deals with the agency. The main rule deals with the service, the provider deals with the agency. As in, the main rule says the place of provision of service of transportation of goods shall be the place of destination of the goods, where the goods are being destined to. The proviso says place of provision of services of goods transportation agency shall be location of the person liable to pay tax, because in GTA it's a reverse mechanism situation. Illustration as provided under the education guide. A consignment of cut flowers is consigned from Chennai to Amsterdam. The place of provisions of goods transportation service will be Amsterdam, outside India, hence not taxable. Conversely, if consignment of crystal ware is consigned from Paris to New Delhi, the place of provision will be New Delhi and hence the same would be taxable. Moving on to the next rule, that is the rule 12, which deals with place of provision of services provided on board a conveyance. And it's quite simple. It says place of provision of service provided on board a conveyance during the course of a passenger transport operation including services intended to be wholly or substantially consumed while on board, shall be the first scheduled point of departure of that conveyance for the journey. A movie in demand, Kolkata-Delhi, Bangkok, Kolkata-Delhi flight, it's going to be Bangkok, not taxable, as is provided in the illustration provided in the education guide. Rule 3 is a general rule which gives powers to the central government to come up with rules in terms of if there is any kind of anomaly happening, double taxation happening, so they have the powers to notify or come out with any other rules. And rule 14, as we were discussing, is the rule which says that if a service, a particular service is classifiable under one or most two services, then the rule that comes later would be the appropriate rule where the service is going to be classified. There is a very interesting illustration provided over here which says that an architect based in Mumbai provides a service to an Indian hotel chain which has business establishment in New Delhi for its newly acquired property in Dubai. If Rule 5 were to be applied, the place of provision would be the location of property, that is Dubai. That is outside the taxable territory, no service tax is payable. With this result, the service tax would not be taxable. Whereas, if you go by the application of Rule 8, as Naresh was pointing out, both the person who is providing the service and the person who is receiving the service are located in the taxable territory. The place of provision would be the location of service receiver, New Delhi. In terms of place of provision rules and read with Rule 14, the later rule will apply and the entire service is going to get taxable. Now we move on to case studies. Ashit Bhai yesterday was kind enough to send us around 14 queries which had come from fellow members, and of course due to the time constraints we have just picked out 8 of them, and let's deal with these case studies one by one. The first case study talks about a firm, that is ABC Private Limited, which is providing depository services to various clients. Now ABC is not a banking company, not a financial institution or a NBFC. ABC has certain NRI clients who are situated outside India and do purchase and sell shares in India, and their demat account is maintained by ABC in India. ABC recovers the demat charges and other depository charges, which are annual account maintenance charges, from the NRI client. Now the question under consideration is, in terms of the POP rules, whether service tax is payable on services provided to NRI clients. Now in terms of our opinion, the above situation is very well covered under Rule 3 of the POP rules. Under Rule 3, the place of provision of service would be place of service recipient. Since the NRI, the service recipient, is situated outside India, the place of provision is going to be outside India, and therefore no tax will be payable. In the aforesaid scenario, there is a possibility the department might say that the service tax, services fall under Rule 9 on the ground that services provided by ABC are in nature of intermediary services. They are intermediary services, you are facilitating a service, and therefore you will fall under Rule 9. Now what can be the reason for department to categorize under Rule 9? Because Rule 9 says the location of the service provider is the location where the taxable territory has to be determined. In this case, the location of service provider is going to be India. It's going to be in department's interest to say that it's going to be Rule 9, and therefore the tax will be payable in India. The argument over there would be Rule 9 of POP will not be applicable in this case, since the education guide issued by CBSE has categorically clarified that stock brokers are not covered under Rule 9. As we saw the question over there, it clearly says that the ABC Private Limited company would be dealing in purchase and sale of shares as well. And therefore, what is the relevant portion of education guide? For the purpose of this rule, an intermediary in respect of goods such as commission agent, that is buying or selling agent, or a stock broker is excluded from the definition. Even if we ignore what the education guide says, what is the definition of term intermediary as I was reading just some time back? He has to be a mere facilitator. His service has to be distinct. It cannot be in line with the main service. Over here, the service provided by ABC is a service in itself. He is not facilitating service between two people. For example, if ABC Private Limited over here would have been the link between the share broker and the foreign party, we could have said ABC is an intermediary because he is facilitating the service between two parties. In this case, ABC is providing the service itself. So in terms of the definition of the term intermediary, he will not fall under the category of intermediary. And therefore, going by the strict provisions of POP rules, Rule 3 will be the only rule that will be applicable. The service recipient is located outside, therefore the taxable event happens outside and no tax is going to be payable.
What is the logic between commission agent for goods and commission agent for services? You said commission agent for goods are not covered under that.
No, commission agent for goods per se would be in a situation where I am actually the person who is wanting to buy goods into India. I am actually dealing with a situation where I am showing him the goods. I am taking the responsibility of the delivery of goods to come into India. The goods should go to the right person. The responsibility of the ultimate delivery of the goods is on me. In terms of service, my service is going to be, I am going to go identify the buyers in India. I am going to give the name of the buyers to the party. Then the party or the overseas client is going to get in touch with all the parties in India and the transaction is going to be proceeded.
Scope of services within.
No, scope of service, and I don't have any control over the goods once they come into India. My service stops once I tell the foreign party that these are XYZ are the name of the clients who would want to purchase these goods from you. These are their numbers, please deal with them, please send the goods to India. I have got absolutely nothing to do with what happens with the goods thereafter. If subsequently I say that yes, let the goods come into India, I will take the delivery on your behalf, I am going to go, I am going to sell the goods, I am going to collect money and I am going to give it to you. That is where you come with commission agent in terms of goods, commission agent in terms of service. The Tradis case that we are talking about, that's the only case under the POP that has been done by an AR authority, where the issue was identical. He was a consignment agent in terms of service. His role stopped the moment the names of the parties were given to the overseas clients. The AR authority has held that that's going to, it falls under Rule 3 and no service tax is going to be paid.
Just to answer the query that you said that what is your concern, and the rationale. So your concern is that what is the rationale behind saying that, because that is what they have done by the guidance, where they have said that what is excluded are people who actually deal with intermediaries who deal with goods. That they lead you back to the definition of intermediary. And if you look at the definition of intermediary within the, because we are talking of service tax, if you look at the definition of intermediary in the POP rules, it clearly says intermediary means a broker or an agent or any other person by whatever name called who arranges or facilitates a provision of service between two or more persons. They cannot, because ultimately a person who facilitates the sale and purchase of goods.
No, it is a service, there is no doubt about that.
But what are we dealing with here? For POP rules, so to speak, they wanted to deal with something which is pure service, an intermediary for pure service. You have a situation of a commission agent who actually deals with goods, and he is also taxable. So there is a situation where he is also taxable, but there you have an identified element which is goods which are being supplied. So you know, as a person who is dealing with goods, you know what you are dealing with. But when you are dealing with a provision of service between two people, that is where the problem really lies. That who is the provider, who is the recipient, where is it that it is being provided. When the goods travel from one person to the other, it is actually physical movement. But when you talk of service, you are not talking of a tangible, movement of anything. It's an intangible that is moving from one person to the other. The very reason you have these rules is to deal with such intangibles, not tangibles. In a commission agent with goods, it's tangible. The goods are moving from one supplier to a receiver. But in case of an intangible, something like a service, all these questions come along. Where is it moving from? Is it moving from a foreign territory to an Indian territory? Is it a case of an export? Is the recipient and provider both based in India? Is the recipient outside the country? Where is the consumption happening? So the rationale behind keeping the goods part of it outside is this.
Naresh bhai, the real issue probably may arise when the commission agent is acting for both, is doing commissioning for both the services as well as product.
Maybe. So therefore again, the situation there will not be any different from, so whether it does standalone services or it does standalone goods or it does both, the situation will remain the same. You will yet have to, for the purposes of goods, there is no doubt. For the purposes of goods, you know who's the provider, you know who's the recipient, and therefore there is no difficulty because you are facilitating the sale of goods between a provider and a supplier, therefore, and a recipient of those goods. So you are very well sure of where the service is flowing. But in case of a service which is being provided, which is an intangible, you are not sure. So let's say in your example of a software, who is the provider and who is the recipient? How are you exactly going to deal with a software type of a scenario? It is to provide for that you have these rules.
Answer. It not raise the basic section 66 where it says all services provided or agreed to be provided in the taxable territory.
So
Now email service is provided in India.
yeah.
The receiver may be NRI.
No.
Why it should not be?
No, but then in that event, in spite of the taxable territory definition being as it is, there is a specific rule that is carved out.
It cannot be beyond the section.
No, rule cannot be beyond the section, but it is the government which is with its own. It's basically, it looks like it is a deliberate or it is a actual. What do you call that term? It's something that is planned. It is not something that is, this shows the intention of the government that in such a scenario where the taxable, where the service recipient is abroad, in terms of Rule 3, the taxability is going to be that no tax is payable. It's a deliberate measure or an intention shown by the government that in these kind of transactions no tax will be payable, in spite of the fact that Section 65B says that the service tax will be levied on, or tax will be levied on services that are agreed or provided in the taxable territory.
Don't you think the rule more will be also affected because the sales are goods?
Huh? No, but then in that event, the goods over here are not provided by the service receiver.
There is no performance.
There is no performance. There is no goods that are being provided by the receiver. It's being purchased by the depository from the market.
I think the question that Narendra put it very rightly, that what you really need to look at is the transaction. What is the role of a depository? He is actually unlike a share broker. See, a share broker may also act as a depository, which is a very different issue. The question here, if you go back to the question is only limited to a depository. What is the role of the depository? And in a very, very basic layman's understanding, depository, he is in that sense, a trustee of the goods. Okay, he acts more like a trustee of the goods and therefore he is paid for that. So, and the goods there are shared. So therefore he is not performing anything, any role qua the goods.
And more so, you don't fall under the criteria specified in the Rule 4. Rule 4 has got two criteria, 4 and 4B. Either of the criteria are not fulfilled in this kind of a case. First is the goods have to be delivered, that is not there. And the second criteria over there is that the service recipient's physical presence has to be there. So both are not, and to the question of 66B being against Rule 3. See, 66B says that tax has to be payable on goods, on services that are provided under the taxable category. Now, how do we find out what is the location? For location, we have to take the help of place of provision rules. Now, in place of provision rules, there are no other rules that talk about this kind of a scenario. So you go into the general rule. The general rule is Rule 3. Rule 3 clearly says that in case, if this kind of in this kind of a scenario, if the service recipient is abroad, the place of provision would be abroad and therefore no tax would be payable. So therefore, After section 66B, to determine where is the place where the service is being provided, you have to take the help of these rules. And that is where the answer lies.
Most of the women, these companies are charging service to NRIs.
They're playing a safe bet, I guess. I mean, because at the end of
At times I must tell you that we may have hundreds of arguments on this, but ultimately I would what as a company, when you are planning it out, what are you going to do? It's a pass-through mechanism. So therefore I might as well pay this, pass it on, and take credit of it rather than suffering a consequence at a later point in time.
And tell me, today it's very difficult for us to go and catch hold of the Indian guy to whom we have provided service. These are overseas clients. So therefore, rather take the risk on their own head, it's better to just pass it on. Moving on to case study 2. Over here, ABC Private Limited is conducting insurance broking business in India jointly with a foreign company XYZ Inc. For this purpose, ABC and XYZ has formed a company PQR Limited in India. After a period of 5 years, ABC decides to quit the insurance broking business and gives a NOC to XYZ to continue business with other Indian company. That is very important. It gives a NOC to XYZ to continue business with other Indian company. ABC further agrees to not to carry the insurance broking business in India for the next 3 years. For this purpose, XYZ Inc. has paid a sum of $5 to $5 million to ABC for issue of NOC as well as for the non-compete fee. The question that falls for determination is whether service tax is payable on the non-compete fee paid by XYZ Inc. to ABC Private Limited under the POP rules. The answer to that is, when it comes to non-compete fees are specifically defined under the declared services in terms of section 66E5, section 66 capital E small e, which says that any service in relation to agreeing to the obligation to refrain from an act would fall under the category of declared services. In the present case, the aforesaid service does not fall under any of the categories listed from 4 to 6 and 9 to 12 of the POP. Therefore, Rule 3 would be the general rule where we have to fall. Rule 3 of the POP would be applicable and the place of the provision of service would be the location of the service recipient. Since the non-compete fees are being paid by XYZ, which is located outside the taxable territory, the consideration is in convertible foreign exchange, the non-compete services will tantamount to export of service covered under Rule 6A of the service tax rules. The result would be no tax would be payable. However, we were just, while me, Naresh Bhai and my colleague Nandagopal were discussing this issue, we were just looking at various combinations as to what can be a different angle that can be in this matter. So we have thought about a situation where it says, what would be a situation if XYZ Inc. forms a new company in India with the new Indian company and the money, that is the non-compete fee, is paid by the partnership firm, that is the new partnership firm or the new company that is coming to India. Because there is very well a possibility that XYZ may say, the new company, that boss, I am paying this non-compete fee so that you and me can do the broking business into India. So why not you also share your 50% in this? Both of them come together, form the company, and after forming of the company, this 5 million USD is paid by the company that is newly formed in India. What is going to happen then? In that scenario, the entire taxability is going to change. How? If the amount is being sourced through the newly formed Indian company between XYZ with its new Indian partner, then the service receiver would be the Indian company. Because the new company that is formed into India will have its fixed establishment in India, which will be using and consuming the said service. Therefore, if the payment is received through the newly formed Indian company, the location of recipient would be within the taxable territory and service tax would be payable. Same transaction, if the money is directly routed through the foreign party in terms of Rule 3, I will not be required to pay any tax. The money is coming to me through convertible foreign exchange, it amounts to export of service, no taxability. However, if in terms of the agreement, the new company, the XYZ Inc. forms a new company with an Indian company and has a fixed establishment in India, the money is routed through a new company, then in terms of Rule 3, the taxability would be in India, because the service, the new Indian company will have its, will be in the taxable territory.
This case, the NOC would be given still to XYZ or it would be to the partnership from whom the payment is?
No, it would be given to XYZ because the company ABC will have nothing to do with the new company that joins hand with XYZ. Originally, the agreement between the two companies ABC and XYZ was that if anybody wants to leave the broking business, then that person will not be doing this business for the next 3 years, and for that one complete fee would be paid. So therefore the agreement was always, because at that time it was never, this scenario was never thought that a new company would join hands and then the non-compete fees would be paid by the new company.
So it's only just the payment mechanism is being routed.
Yeah.
But the service receiver still would be XYZ only?
No, service receiver would not be, service receiver would be XYZ. But over here, once a new company is formed, suppose XYZ joins hands with PQR and a new company is formed, the new company over here would be paying this amount of non-compete fees to ABC Limited. So technically speaking, after receipt of this non-compete fee from the new company, ABC would be giving a no objection certificate to the new company that fine, I have got no problem with the new company, carries on with
Otherwise, you are right. This situation actually,
that we thought about this situation.
when he put this query, I had the exact same, question to him and an answer saying that what happens? So who's going to give the NOC? You're right, absolutely.
Let's move on to case study 3. This is, again, we have ABC Private Limited, common everywhere, has an office premises at Nariman Point, which is the only asset in its balance sheet. Similarly, ABC has only rental income in its statement of profit and loss account. XYZ Inc. wants to buy the office premise and has appointed a real estate broker, Mr. Y, to assist him in purchase of office premises. The shareholders of ABC Private Limited wants to sell its office premises by way of sale of shares, which is purchased by XYZ Inc. Mr. Y has assisted in this deal to XYZ Inc. and hence charge his fee to XYZ Inc. So therefore, if I read the question correctly, there is no direct consideration in cash flowing from XYZ to ABC. The consideration is flowing in the form of XYZ Inc. purchasing shares in ABC Private Limited and ABC Private Limited transferring the property in the name of XYZ Inc. That is what the question means. Now, the question that needs to be decided is, beside the applicability of POP rules to payments made by XYZ to real estate broker, that is Mr. Y, as brokerage for assisting the above mentioned transaction. Now, if you actually look at this transaction in a very normal manner where the consideration would have been paid in cash, the services are being provided in relation to immovable property, you fall under Rule 5. The place of provision is going to be where the immovable property is located, and therefore the services provided by Y are going to be taxable and tax will have to be paid on the brokerage fee. Now over here there is a slight twist which says that the shareholders want to sell the property by way of sale of shares. Even in that kind of a scenario, we don't think there would be any difference in the answer, because if you see the language used in Rule 5, it says that services provided directly in relation to an immovable property. The word used over here is directly in relation to immovable property. Therefore, the phrase in relation to immovable property is to be construed widely and would bring the above service of facilitating the sale transaction under Rule 5. Irrespective of that, today, who is the person who has provided the service? He is Mr. Y, who is a broker. He is going to charge his brokerage by way of whatever is the brokerage fee decided between him and XYZ. Why is he charging the brokerage? Because there is a sale of immovable property that he has facilitated. So therefore, even if the sale transaction or the consideration is paid by XYZ by form of purchase of shares, it will not have any bearing on the transaction. The transaction is in relation to immovable property. Immovable property is in the taxable territory. Tax will be required to be paid in this kind of a scenario. No, there has to be a transfer. What's going to happen if... No, there would be. Because why would... what is the benefit XYZ Inc. gets by purchasing shares of ABC Private Limited? No, the question that was put is ABC wants to, XYZ wants to buy the office premises and has appointed real estate broker Mr. Y to assist him purchase the office premises. Yeah. No, but the transfer of shares you're talking about is the shares of ABC Private Limited. At the end of it, what is the benefit that XYZ Inc., if I ask myself a question, what's the benefit that XYZ Inc. gets? No, that would be a deciding factor because
Okay, let me put it differently. What is the question? The question is that there is a company which wants to buy the office premises and has appointed a real estate. The moment you say that you want to buy office premises, the manner in which you actually provide the consideration, what is the first, what is the first, if I may say, activity? The first activity is buying a immovable property. Okay, you are buying an immovable property. While buying the immovable property, you tell the person that, look, I want to buy this property. There is a crore of rupees which this property would otherwise, cost. I would, instead of paying a crore in cash, will give you shares worth a crore. That is the transaction. So there has to be a registration of the property.
No, but what is the use of the Mr. X coming as a broker in this kind of a transaction?
Yeah. So what? Yeah, I know. I understand what you're saying.
But because the transaction initially suggested that it is for purchase of property, it may get the
Yeah, I understand what you're saying.
No, tax over here is not paid on the transaction between XYZ and ABC. The tax over here is paid on the services that are being provided by Mr. Y. That is the most important factor.
And let me tell you, the problem will be something else. It is not a situation. This is a situation where you are giving the consideration by other means rather than cash. Now it is not. Therefore, it is not a situation that the property will not actually be sold and it will not be registered.
Just to add, in the question, what they want, the issue is that they're saying that rather than giving the premises on rental, so to sell the premises,
that is how now I understand, because otherwise the one way of looking at it is that you are selling the property, but the consideration flows in a different manner.
That was the understanding that
different manner. So that was the understanding on which we proceeded, but I understand now what you are trying to say.
No, okay, that is right. But then in that event, what is the service that is being provided by Y? There is a service provided by Y. The Y was the person who actually got this entire transaction to start with. So therefore, the service element, the service tax element over here is not the transaction or what the money that has been transferred between, the money consideration that has got transferred between XYZ and ABC. Here, the service tax amount that we have to decide whether it is payable or no is on the services of broker Y. As long as broker Y has provided a service in relation to an immovable property, you fall under Rule 5.
Essential services is for transfer of shares from the shareholders.
No, that's what we understand. But as we originally understood
So therefore you're right. So now it's a matter of classification of how. That is the document.
Classification here is that then the service receiver is foreign company and it might get
exemption, correct. Correct.
That's valid.
But the first line is important, where it says that only asset in the balance.
Correct.
Yeah.
That is very important.
Yeah.
Some other assets are there in the balance sheet, then the answer would be different.
Yeah. No, you are right on that. But when we actually prepared an answer to this query, as we said, the understanding that we got was...
So yeah, you're right. So therefore now the question is that, now the scenario changes. So what is the answer in the change scenario?
Change scenario.
Yeah, I take your point. That correct, absolutely. And what is what is the nature of the sale? So the nature of the sale is actually the sale of goods, because it's shares.
So we go to rule 3 now.
Yeah.
If you go into rule 3, then of course, as you rightly said, it's a recipient.
Yeah, so therefore you're right. So therefore one will actually have to go by the nature of the transaction as recorded in your books, which ultimately will be shown to the income tax authorities. If that is accepted, then you're right. Then this situation,
you go into rule 3.
nonetheless there will be some explanation which you will be required to give to the authorities if they come to your doorstep. Yeah, you have to modify the documentation. And here you're right that there is no changing of hands insofar as the property is concerned, because you will not get the property registered in the name of yeah.
Okay, sorry. The next case study is ABC Company, an Indian company, and provides for recruitment services to clients located in India and outside India. Some of the overseas clients have their fixed establishments within India, like a branch or a subsidiary or associate. The recruited person may be placed by the client at their fixed establishment outside India or in India. The contract of service is executed between ABC Company and the overseas client. Invoice for provision of service is issued by ABC to the client, and the payment is also received directly from the client. The location where the candidate is to be placed is known to the company right at the time of entering into the contract. Now, before I proceed with the answer, I am taking over here that the contract that we are talking over here is between ABC and the foreign overseas client. That the ABC at the time of entering the contract very well knows that the candidate that he has given is going to be placed either in India or is going to be placed abroad. So the question is what's going to be the tax liability in both the scenarios, outside India and in India. In terms of this, the place of provision of service for the above scenario is to be determined under Rule 3, that is location of the service recipient. Therefore, question is who is the service recipient in the present case, and whether it is the foreign client or the branch of the foreign client in India. When it comes to person recruited outside India, it's a no-brainer, no question about it, there won't be, it's outside the taxable territory. The problem arises when it comes to persons who are recruited in India, because the person over here, ABC Limited, always knew when it was giving its candidate where he is going to be appointed. He is going to be appointed in India or abroad. The overseas client company receiving the recruitment services also have places in India. That's what the question says. So therefore, one has to over here look what is the definition of location of service receiver as given under the POP rules. And it says where services are used at more than one establishment, whether business or fixed, the establishment most directly concerned with the use of the service. Now this has been simplified further in the education guide, and the education guide says that in case of multiple establishment of persons, the establishment that actually provides or receives, and in bracket it has been categorically stated, uses or consumes a service, that establishment would be treated as directly concerned with the provision of service, notwithstanding the contractual position or invoicing or payment. This is what the education guide clarifies in terms of the location of service receiver rule definition. So therefore, in the present case, if the recruited employee comes to India, then the services is directly used or consumed in India, and the contractual position or invoicing or payment will not have any bearing. And therefore, in this kind of a scenario, the tax would be payable because the service recipient would be Indian, would be within the taxable territory.
In my opinion, the recruitment service and ends with the placement of the candidate. So that is not the criteria whether his employee is using
No.
the recruitment service is provided to the foreign.
You have to see the complete benefit of the service over here. Nobody is ever going to pay any amount to a recruitment agency for giving the names of the people.
That's right.
So only if the candidate is selected. Over here there is a specific mention in the question that ABC Limited at the time of entering of the contract knows where his candidate is going to be. So ultimately the benefit of the service provided by ABC is going to be felt in India if the person who is recruited comes in India. The service only ends there. The service doesn't end midway. Likewise, if a person who is recruited goes abroad and he is recruited abroad, what happens then? The service only ends when he is recruited abroad. It doesn't end the moment the contract is signed. But at the time of entering into the contract, we very well know where the person is going to go. Therefore, the use or the consumption of the service in this place, otherwise there was no purpose of they using the words uses or consumes. That is very important over here. So therefore, going by what the education guide says and by the definition of the term location of service receiver, it would be safe to say that service tax would be payable in such a scenario if the person is recruited in India. Quickly going to case study number 5.
Sorry, I'm yet stuck on this case study number 3 and excellent tax planning, but I'm just a thought, I'm just wondering that, why would anyone want to actually do that given the current, so you have a Vodafone type of case where, this entire tax planning is only for the purposes of avoiding one tax, whichever it may be, whether it's income tax or whether you are trying, there is no other business purpose, behind this. And with the current, circular which has now come out by the MCA and the CBDT, I think this sort of a transaction will absolutely fall foul of that. Correct, absolutely, and that's.
The problem is only of immoral property taking into balance in the
Correct, and that's the reason, and my thought, in fact, was always, and when I saw, sale of shares, the thought was that it's only the sale of the immovable property vis-a-vis the share, so therefore the consideration was share. But now when you said what you said, I also started thinking in other directions also, because this is a clearly Vodafone type of scenario where, they're going to catch hold and they're going to say that this is purely to avoid tax.
In fact, almost all the telecom operators today have been visited with various huge demands for just transferring the business undertaking and just so many. I mean, almost all the telecom operators who have been.
Otherwise, the scenario would have been the same scenario, where you would otherwise have to rent all those transmission towers.
Yeah.
Going concern, absolutely.
This kind of a transaction had a major problem with one of the telecom concerns, which we appeared before for the High Court, in the High Court. They were visited with a tax demand of 1,500 crores. And recently, not recently, around 4 to 5 months ago, we were able to obtain an unconditional stay from the High Court. It was similar transaction, where the business undertaking moved hands and the sale of shares took place. And the tax authorities are asking the income tax on the entire demand. So therefore, that's what, as Naresh said, even I was actually wondering why this kind of tax planning, because either here or there.
Structuring is important.
Yeah, structuring is very important.
Correct. Sorry?
I would think it will become far more difficult.
Sale of shares. No. Rule will change.
Absolutely, you are right.
That's an excellent tax planning, and that's what.
So therefore, this tax planning thing, the moment you said that, it started thinking that how is this going to help one way or the other. It is only a situation where it may land into further trouble.
Yeah.
Anyway, we can move on.
Okay. Okay, now let's move on to the case study 5. Over here, finally we have a change in the name. Sargam Limited is in the business of supplying contents such as songs, wallpapers, etc. to telecom operators. Such songs are downloaded by the customers of telecom operators through WAP connections on mobile phone In few cases, telecom operators are located in JNK. Which POP rule will be applicable in such a case? Rule 9B is very clear on this, which says that online information and database access retrieval service, and examples in the education guide is mentioned, web-based services providing access or download of digital content. So in terms of rule 9, since is deemed to be provided where the service provider is located, in this case the location of Sargam Limited will be relevant from the taxability point of view. And if Sargam is situated in any part of India other than J&K, service tax will be deemed to be provided, service will be deemed to be provided, and it will be taxable. In relation to case study number 6, company ABC is incorporated in Bhutan, and ABC is developing a township project in Bhutan. ABC has appointed consultants from India saying XYZ Limited to provide various consultancy service in relation to the project to ABC. The consultant XYZ raises invoice in INR to ABC and ABC makes payment to XYZ in INR only. Whether XYZ is required to charge any service tax on the service provided to ABC. In our opinion, XYZ will not be required to charge any service tax on the service provided to ABC if the service is not within the taxable territory. The relevant provision for determining the place of provision of service for the above scenario will be Rule 5, which clearly says where the immovable property is situated. If service of the consultant is directly, so therefore what it basically says is if it's outside the taxable territory, no tax would be payable. However, there is one very distinguishing factor which says that the invoice is raised in INR and the amount comes in INR. A thought comes to one's mind as to what's going to be the effect under Rule 6A, which talks about export of service. Whether this will be treated as export if convertible foreign exchange is not coming into India, if it doesn't qualify into export, then whether tax would be payable. After much deliberation, the answer that in our opinion would be that Rule 6A and Section 66B are two different rules which actually have a different application altogether. There is a possibility that a service might be outside the taxable territory and therefore not taxable, but it is not necessary for that services to be termed as export of service. No refund mechanism, no rebate mechanism. So therefore, at best, if you don't fall under 6A, you will not be able to get the benefits of export, but that doesn't mean that since only because the money is not coming into India as under convertible foreign exchange, service tax would be payable. That in our opinion would not be proportionate. No, that we have stated.
This is again a quantum shift. If you really see, look at the policy of the government. The policy all along has been no tax where you have an export. This is a situation where you will not get the refund and you won't get a rebate. And there is a situation of tax of export.
Technically speaking, even though no tax is payable, you will end up importing or exporting your taxes because all the input credit and everything that you have will become cost to you. So therefore, technically speaking, in such a scenario, the only option available would be to capitalize the cost, and you'll end up exporting the taxes, which has never been the intention of the government. Now, one of the questions that was raised in relation to this was that if an amount of 6% is paid on the value of exempted service, whether XYZ can recover the same from ABC. Now, this is a very settled issue in terms of excise. We used to face a lot of issues in excise where the department used to raise show cause notice under section 11D, but since it is not a duty, you could not have recovered it. Since you have recovered it, it becomes an additional consideration. The same will be included in the assessable value. The government has come out with a circular on this. I have stated that there is no problem in recovery of this amount, in spite of the fact that this is paid under Rule 6, because at the end of it, this amount is first deposited with the government and then collected. However, the government has clarified, and rightly so, that since it is not duty, no send-back credit of the same would be available. Amount under Rule 6, reversal under Rule 6.
You don't call it duty at all.
We come to case study 7, which deals with GTA. ABC India has obtained services of GTA located in India for transporting certain goods to XYZ, an entity in Nepal. The freight is to be paid by XYZ. Discuss the applicability of POP rules. Rule 10 is applicable in this case, which provides that place of provision of service of transportation of goods shall be the place of destination of goods. In the present case, the destination of goods is Nepal, which is outside the taxable territory. Even if we go by the proviso to Rule 10 states that place of provision of service of goods transport agency shall be the location of the person liable to pay tax. In the present case, it's clearly stated that the freight is going to be owned by XYZ, which is an entity in Nepal. So in either of the scenarios, you go by the main provision or go by the proviso, there won't be any tax liability in this case. And we come to the final case study.
Nepal by Jammu and Kashmir are absolutely the same.
Yes,
Remains the same.
Yeah. Let's go to the final case study. Here we have a courier company.
Just to add on that case 7, if you refer to rule 2 and D, there they say
Yeah.
that the proviso is there.
In case of goods transport agency, reverse charge mechanism is what you're talking about.
Yeah.
So the provision says that where such person is located in non-taxable territory, in this scenario, the provider of such service shall be liable to pay service tax. Whether that will have any...
1 second.
The agency will liable to dispatch.
No, but then... No, in that, if you go by qua the agency, the proviso clearly states that place of provision of service of goods transport agency shall be the location of person liable to pay tax. Whoever is liable, in terms of this proviso, the place of provision doesn't change. The place of provision will have to be as per Rule 10. Rule 10 clearly says the place of provision will be the person liable to pay tax. In this case, the person liable to pay taxes is on a taxable, is outside the taxable territory. So therefore, in my opinion, it will not have any change in the bearing to rule, because Rule 10 is a rule that has to be considered. We go to the final slide. Courier company C collects the parcel from Mumbai customers and delivers it to company D, which is another company in UK. Company D in UK is again a courier company which doorsteps the consignment to a consignee in UK and raises a bill on company C. The question that needs to be answered is on this transaction whether any tax is payable. Now, if we look at Rule 10, Rule 10 clearly says that courier companies are excluded from the purview of Rule 10. So, the only option remains is to go back to Rule 3 because there is no other rule that will... No, because under Rule 4, again, the goods that are being... it can fall in the... Yeah, it can fall in the... Yeah,
Those are provided.
yeah. But then again, if you even go under Rule 4, it talks about location where the service is performed.
So in this case, if the contract is post UK, then no service tax applicable.
No, but that's a... If it's qua India, then there is no question at all. But if it's only in relation to UK, then whether you go under Rule 3 or Rule 4, the answer doesn't change. Yeah, because it is, in both the cases, it's right, you're right. In one case it is service performed, in another case it is location of service recipient. So the answer doesn't change.
No, that is what I was coming to, that Rule 4 may not apply.
No,
Because there is no activity which you are undertaking on the goods.
No, but there is no activity being taken.
Unless if you look at Rule 4, the manner in which it is couched, it has to be an activity and a value addition on the goods which otherwise does not amount to manufacture.
But then if you go to the true interpretation of Rule 4, then maybe what you are saying also can be an interpretation. Because it says service.
No, I'm saying that
It can be interpreted. It cannot be a completely wrong interpretation.
So, yeah.
It says services provided in respect of goods that are required to be made physically available. So services are being provided in respect of goods.
Services of transportation of goods.
Transportation itself is a service.
No, transportation is still a service, but the goods that are being transported are being provided or physically made available. So there can be, but any which ways, whatever the interpretation, maybe it won't make much of a difference because the location or the performance of services are abroad. That is in UK.
Education there also in the example they give courier services.
Okay.
In your next slide only, in fact, probably examples under Rule 4.
We have stated that. We have stated that. Yeah. courier services are excluded from Rule 4. So therefore, तो फिर Rule 3 हो जाएगा. Anyways, thank you.
Before proposing a formal vote of thanks, one announcement. All the members who have not yet paid for the renewal for this study cycle, all the members are requested to pay for the renewal for financial year 14-15. Now coming on a pleasant task. I'm sure everyone is going to agree on this point that the knowledge was impeccable. It was right. We have they have taken us right from Rule 1 to Rule 14, and also touch upon the issues wherein we can say that the rules are ultra virus, whether we can challenge the constitutional validity or no. Sir, we thank you for taking your time from rather very busy schedule, and being here and guiding us as to how to deal with the provisions practically, and also we really bore you on the fact that in spite of being stuck in some urgent matter and your client being sitting at your office, still you been here for us. Thanks a lot, sir. Thank you. Thank you.